242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I'm here under special appearance and under duress to address this matter. The Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything, and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
Welcome back, everyone, and buckle up because today's video takes us straight into the bizarre and often unbelievable world of sovereign citizens of two defendants, two courtrooms, and double the chaos. First up, a man who's not only decided to represent himself, but is literally reading his pseudo-legal manifesto off a piece of paper like it's a sacred scroll. Then, later, we revisit Michael Valentine, a repeat star in this courtroom drama. And yes, he's back with an update that you won't believe that today's story isn't just about defiance. It's about how logic and law collide with internet conspiracies. You'll see judges holding their composure while defendants turn hearings into sovereign word salads. And we'll be breaking down exactly why those arguments never work. Plus, what really happens when you try to opt out of the legal system. Grab your popcorn, because by the end, you'll know the difference between constitutional rights and constitutional nonsense. And trust me, you'll want to stick around for the second case. It's got twists, substance violations, and enough irony.
I have to go over a few things with you to make sure you understand them, okay? You're charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree. I'm asking if you understand.
Present myself moment. Always sounds empowering, right? Until the judge reminds you that representing yourself means you're still bound by every single rule of law that an actual attorney spent years learning. This is where many sovereign citizens get tripped up. They believe representing themselves frees them from the system, when in fact, it locks them asterisk deeper into it. Judge Shackelford's calm warning here isn't sarcasm, it's experience. She's seen this before, and she knows exactly where it's heading. Let's take a moment. Would you ever choose to go head-to-head with a professional prosecutor armed only with Google law degrees and TikTok tutorials? Let us know below, because this is the kind of courtroom confidence that comes with consequences.
Join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today.
Cocaine is a hell of a drug.
And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously court.
Every sovereign citizen video seems to include this ritual, claiming to be a beneficiary of a constitutional trust while speaking in half-remembered Latin. But what's really happening here is an attempt to separate the person from the legal entity, the bizarre belief that by declaring yourself sovereign, laws stop applying to you. But Judge Shackelford doesn't flinch. Notice her patience. She's letting him finish, but she's already heard every variation of this script. The irony? He's literally reading freedom off a script written by someone else online. Yours.
State previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted that the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release condition only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet. And they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state...
This right here is what seasoned judges do best. Control the room asterisk without breaking a sweat. Hackle Ford doesn't argue, doesn't mock. She just redirects. By calmly saying, submit it in writing, she effectively removes the sovereign stage. That's how you take away their oxygen. No conflict, no chaos, just pure procedure. She even lets him know he's bound by the laws of Michigan. A subtle but firm reminder. This isn't Reddit. It's a core true. For all the talk of jurisdiction, the one person clearly in charge here is wearing the robe that if you were in her shoes, would you interrupt or let him talk himself into trouble? Drop your take in the comments, because Shackelford's patience is textbook judicial judo.
Question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. You're
Yeah,
not
we got
waiting for
everything.
intox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
Now comes the moment every sovereign dreads, the actual charge. Interference with police authority may sound minor, but it's serious. Up to 90 days in jail and a $500 fine. And notice how methodically the judge reads every right aloud. The right to counsel, to remain silent, to call witnesses. This isn't just routine, it's bulletproofing the record. Why? Because when defendants later claim the court didn't inform me, there's video proof that every constitutional right was explained to tease moments like these where the fantasy of being above the law collides headfirst with the system's precision. Ever notice how quiet sovereign citizens get when the real-world penalties are read aloud?
So
Even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right, so you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're two separate cases now.
All right.
And we're back, but this time with a familiar face. Asterisk Michael Valentine, or as he likes to be called, American National v. Valentine, if that name sounds familiar. It's because we've covered him before. He's the guy who tried to outsmart the court by redefining his citizenship status. Spoiler, it didn't work out. He's back, but not for jurisdiction arguments. This time, it's pretrial violation star. Positive tests for THC and cocaine. Yes, asterisk cocaine, the stakes are higher, the patience is thinner, and you can almost feel the courtroom energy shift. For you. If you were a judge, would you even entertain another self-representation attempt?
It does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change release conditions, and that was denied. I guess that was me. From the court's docket, that's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount to, because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing.
This is where things get intense. The prosecutor calmly lays out a clear pattern: violations, broken conditions, and repeated noncompliance, all within a month of release. Otis, how methodical that argument.